or combine or conspire with any other person or persons to monopolize any part of trade or commerce among the several states or with foreign nations shall deem to be what? Guilty. They're guilty already off the bat. Go fuck your goddamn self. You can't tell me that when you create an insurance policy and me, the little one man who have for $500 a month because I am going to have sexual intercourse with this woman every week. That's the only way I could get a $500 in my pocket. That's my goddamn commerce. Oh, we got a lot of prostitutes. Indeed, we don't want a prostitute in the place. It's immoral. But guess what? That's the way she feed herself and her child.
Cool Fox, they had my wife sign a letter saying that I won't drive because of me not having a license. And they told they also made her premium go up because of me not having a license, saying that she's married to me and I'm in the house with her.
Repeat what you said. I think I'm trying to calculate it.
All right, they told my wife that she had to sign a paper to keep insurance, or they was going to cancel her insurance because I don't have a license. You know, I got it suspended. I don't ride with it no more,
Have
anything like
them
that.
send it to you in writing.
I
Have them
think
to send it to you in writing. Once they send it to you in writing, it's considered to be discrimination against.
so. If she have something in writing saying that, because I
Yes,
think that's how they communicate to her was through email and stuff like that. I don't think they talked over the phone or anything, and
right.
they done
So it's a
something to have her sign.
right. So remember, it's a discrimination against to limit any personnel who does not operate in the into material misrepresentation. Once they're gonna tell you it's a state law, then you bring the commerce clause to show the monopolization of the commerce law. It's a restriction of trade and commerce. It's a governmental overreach. It's a contract that she has with the insurance policy to cover a lot of our property and trying to have this liability to cover herself. And then they decided to restrict that from her under the auspices of due to non-licensing. The state
Right.
doesn't have no rights over our property, and she have every right to restrict the state from interfering with our commerce. So what the state did was the state enacted a law to limit contract. That's a violation of Article 1, Section 10.
Huh.
She's in the contract. They make a law to limit contractual agreement, to limit trade. They're in
So is it that
violation of
they
the trade
force her to?
clause.
Is it that they force her to contract or revise the contract by having her sign that paper? That's like a forced revising. Or if you don't sign this
So
paper, we're gonna cancel you.
so no, it's not a force per se. It is a threat, an intimidation of restriction and obligation, using governmental overreach into contract our trade. The government is a third party,
Right.
and interest should never limited only because she doesn't have certain documentation that she don't need to have.
And they took her, made her pay more money a month because I still live in the house with her.
Um, why would they have you pay? This is the new thing that they're doing. They're trying to have you pay more money because you live with your husband or you live with your son. Watch out for those things. Are you in New York City? I guarantee that probably be New York City. New York City, I know New York City doing that shit.
I'm in Georgia.
Georgia probably doing that shit too. I recognize that they trying to make husband and wife or daughter and son. They make you pay more insurance policy. That right there, you guys have to start looking to. You guys need to realize that the insurance policy today, as the young lady or whoever was speaking earlier, was saying that the insurance policy is nothing but a bullshit scheme or a scam. So that's why you guys have to start making those things inside of a trust. If you
Yeah.
understand, I make trusts. So I know exactly what I'm talking about. I write draft trusts. I don't try to offer my trust to sell it to no one because I know what it takes to make the trust and I have to teach you how to use it. So my trust is going to be expenses of free. So don't even bother try to ask me. Right. So the trust inside of it, you can create an insurance policy for every single asset that you have within inside of a trust. House, land, body, daughter, son, you yourself. Right? The insurance policy will cover even the trust of loss of its own assets. And you can use assets inside of that trust to actually cover the liability for it. 15,000, 20,000, 10,000, 30,000, that liability. And on that liability, you can create that bond. With that bond, your trust is efficiently running a sufficient bond in which you can trade upon that bond. You can go to any form of stock exchange, whatever it is that you want to do, and generate currency on that bond itself, right? When they get some currency on that bond, they can use that to fund some more things inside of a trust or build another business and do some sales on the outside and generate more currency for that trust. With that said, you don't have to participate with any outside insurance policy. They ask you for an insurance policy, you provide the insurance policy with the funding of a trust. Your trust is already recorded on the county record or wherever it is that you want to record a newspaper, wherever you think is best as public information, where they can draft it from anywhere. Once they can see that you have a trust established, they don't have the right to ask you for anything inside of your paper. You already cover the liability for your both the car and every single thing. And when they drive, when they ask you for it, you make your own car, they issue to the car to them. They're gonna ask you, oh, we don't know this insurance. Say, you can go fuck yourself. I don't care if you know it or not. When they take it to the court, you bring it to the court and you sue them for fictitious action brought to the court. Because why? You have a liability and they cover the cost for that liability with an asset, with a bond. So since you cover the liability, there's no way nobody can try to invoke that laws on you. So since you have your wife, you create that stuff for her. I see somebody raise their hand. Who was that raised their hand? Bobby? Bobby? Am I still talking to Bobby?
Hi, yes, I'm here. I
Mhm.
have a question as to the territorial jurisdiction because I filed that in my case, and I'm just going to read what the judge said. Um, the alleged judge, he said, first, with respect to leave motion one, there is no lack of territorial jurisdiction. The proper legal principle is the law of venue. Venue is governed by Civil Rule 3. Venue is proper in the county in which the defendant resides, Civil Rule 3C1. And he goes on to say that it wasn't raised in the beginning and venue can't be raised now. And I was like, I'm thinking I never raised venue. I said territorial jurisdiction. They shot it down. I was in another court case and the judge, the assigned judge, flat out told me territorial jurisdiction. What is that? I've never heard of that in Ohio. So I'm dealing with some imbeciles. Like, what do I do about this?
All right. So jurisdiction can be challenged at any time, both subject matter and personal. Even though they might add the venue, they still can. You can still restrict personal jurisdiction from them if you want to still deal with jurisdiction. What is the case is about? Well, you got to understand when you're dealing with court, you got to understand what the venue is. So let's go ahead and type it up and just type it up so you can see it for yourself when you're dealing with court case. So you go ahead and type something like different
It's a
type
it's
of
it's
venue.
a civil case. It's a civil credit card case
Okay,
in
so then
which sorry, go ahead.
in civil cases, a total different aspect when it comes to claim. So you are not a citizen of the same state or same. You can do diversity of citizenship and move it to the federal court. Now, when they deal with credit card, the person who's actually in the court must own the debt, prove that he owned the debt. So you need to see you must have a validation of the debt, and they must ask for standing. You can do an abatement,
Cool
forcing them
Fox,
to.
I've done all of that. I've done the abatement. They ignored it. I put in I did the
Yeah,
what
so
was
do a
that you
removal.
just said?
Do a removal for bias.
I did a removal under the diversity and the federal court sent it back to state court.
Um,
So
so
like
you remand it back,
I don't know what's going on.
remand it back to the federal court. You have to do a remand. Do a notice of
Okay.
remand back to the federal court for bias and constitutional questions of due process.
Okay.
So you go back, you remand it back to the federal court for bias and constitutional question to due process. The requirement is when they do an abatement, it must show standing. Every court rule require people to show standing. It's a federal rule of evidence. So remand it back to
Every
the
time I
federal
try
court. Remand it back to the.
every
Go
time I
ahead.
put that back in, cool file, every time I put that back in, they would say they would strike it from the record. Every freaking time I put challenge standing, stating that they did not have standing, they haven't proved standing, the judge would strike it from the record. Each case,
So
strike it from the record.
now, what did they put on the record?
They said that it was denied and it is further stricken from the record.
No,
That's all they put on there.
what did the plaintiff put on the record?
They didn't put anything on the nothing. Well, no,
What
what
is
they
in
put
their
on there was
complaint?
the
What is in their complaint? What is in
yeah,
their complaint?
it was a complaint and it was an unauthenticated statements. They also they didn't show the standing. They didn't put the agreement, which they should have had when they, put the case on. And it was just a farce. Like people around, a lot of people they don't know. So they're like being led to the slaughter because they think, oh, well, they send me a summons, then I gotta pay this or I don't show up. Well, then you're gonna get a default. But I think I'm one of the few people in this hick ass town that is fighting this. I've been fighting like 5 of these cases for almost 2 years. One I've been fighting for 3 years. They've never seen anything like this, and I'm not stopping. But this striking of the
So,
record and
so
denying all my motions and giving people summary judgments in which they never filed summary judgment in over 3 months, and he's still trying to give them summary judgment. I'm fighting some imbeciles here.
all right. So I'm gonna bring up a documentation here. Let me see if I can bring up a documentation here. I don't think I'm allowed to do it, but I'm gonna try to see if I can bring it up. This is somebody else's case I work on, but I'm gonna try to see if I can bring it up. Let's see. Um,
Oh wow, excuse me, folks. Let me stop this for just a second. It's 5:52 a.m. Pacific Standard Time. I fell asleep. Hold on, I'm stopping the video, audio, and I'm start restarting it. It's 5:52 a.m.
to the wrong
Recording in
section,
progress.
right? Slide over to the wrong section. And when you look at the last part of the E, it's kind of weird. So that means that the left side is a either robo signature or a copy and paste signature.
And that's exactly what it was.
So when it prove in standing, you make an allegation showing the evidence that they don't have no standing. So this would be a perfect example of saying you don't have standing because the note that you brought to the court is invalid. It's fraud upon a court and a fictitious action brought open to induce the court into make a judgment against the interests of the court. So you have to call it out and point them out just like that. So when they say don't have standing, you can't say you don't have standing just because they don't have standing. You got to go inside of the documentation, see what they file in the court case. So at filing, they must come with the proper documentation. Must have standing. So that's a Remora case law. You file a course president of Remora. When they must have standing and filing. So when they file, many of you guys don't know this. Even though you have a credit card, the credit card contract being sold to various party to generate currency for the bank. So the bank, excuse me, so the bank can pay its debt. So they will sell it. So even though you're under face value, the same bank coming to court to sue you, right, is different from the party who actually has the note. Sometimes you have to pay an investigator to find it. Sometimes, if you know the rules, you would go ahead and find it on your own. You can find them sometimes on SEC if they create a different trust or if they create. Give you the
Recording
principle,
in
analyze it and
progress.
see if it's doing anything that you need, and then they bring forth whatever law is it that you take needs that necessary that you believe that come to it, and then say, before I give you this, analyze these laws and see if they match the claim. And then we said, all right, then these laws do not match the claim. These laws match the claim perfectly, or one of these laws do match the claim, but the rest does not match the claim. And it would tell you why it matched the claim and how. So now give you an understanding of what it is that they're coming with. Once they give you that understanding what it is that they're coming with, you can then write your documentation in your own way along with the rules and principle in which you have learned either here or anywhere else, and put them in there and ask it to tell you how does this sound, and then it will tell you how it sounds, and then say no, I want it to be structured enough for court to understand my claim. And when they structure it, you go in there and edit it again and put your verbatim words that you want to be in there, and it would then make a perfect instrument for you. Place that upon the court. All right, because I know I'm not around you to be able to help you to do all of that, and it may not ready to expend any more money right now to take care of case. So that's one of the way you'll be able to take care of that for yourself.
Hey, Cool Fox.
Thank
Yeah.
you. Thank you.
So I have a similar case. A credit card came after me. I went to court already, and what I did it was I looked up they had an arbitration act, and I put in a motion to compel arbitration. and the judge denied it. He said that I showed a sub bullet that said that I have the right to ask for arbitration, that they're coming down the wrong venue. And then their lawyer came and said, "Oh, if you look at this sub bullet, it says you can bring this to court." And I didn't realize at the time that in reality, when it said you can bring this to court, it was referring to me. And so they brought a witness in. All they did was show a redacted document with my address on it, my name, and they had a bill of sale that was not signed by them. And I said, well, this bill of sale is referencing a purchase agreement. They do not have the purchase agreement here as an exhibit, so they lack standing. And the judge went against me, so I had to file an appeal. And in the appeal, I'm fighting that, I did file that motion to compel arbitration. They never followed through with it. And so that's where I'm at, which sort of falls in the same thing that she was saying. The judge just ignored
Yeah,
everything I filed.
one, it's evidence of what you call it, negligence, or you're gonna use evidence of negligence only because you want to be nice first. Negligence or oversight. And then once you're gonna go ahead and you're gonna use the Constitution articles one, that they have to follow the obligation. And you are gonna state the claim that the one that said you can bring this to court, which was referring to you, not to those people. And you affirm to the court that you want to keep it within the arbitrary process. Now, when it comes to the documentation and the note and the transfer, you're going to tell them, hey, I wasn't notified of this. This is a statutory violation. Show them that the statutory violation require when the sale of a product is going out there, they're supposed to give you 15-day notice and 30-day notice before the sale. So all of these things that they have in these little sale agreement or whatever agreement they have in, they never notify me of all about it. If it's not in the category within the category of the court case, I never know of any of this sale. So this is a statutory violation, and they must be penalized on the statutory violation because they must notify you of who is the current owner. And if he's not the current owner of the asset, you need that judicial review. I can give them judicial notice. What I would suggest, if you want to make it even more tighter, if you have the money to get an investigator, to go get the investigator to find the note itself or who has it and see if the debt was sold or it is anywhere else different from what it is. That's why when I take some of you guys' cases really need an investigator, and the investigator charged me an arm and a leg, $2,000, $3,000 sometimes. And you guys probably would pay me $1,500 to do your case. I can't pay that goddamn investigator for go find that documentation for you and work for you at the same time. So when you guys come to me, I'm like, okay, you guys don't even know that you guys are bending my pockets here, right? So you look at $1,500. I charge you guys $1,500 to do the case. I'm gonna have to bend my pocket to pay $500 more to whatever you give me to get this investigator to get the goddamn document for you guys. You might think it's expensive what me charge you. People come to me and say, "Oh, no, the price is too expensive." I'm just saying this because of other people, not because of you. I have to pay this guy $500 more to get your documentation what you need. And sometimes you guys show negligence on your case, that you guys here, negligence on your case, you let the case lost. Now, the reason why I do it like this, I'm gonna tell you right now, is because once you follow the procedures and the rules, when they come and get your claim and the claim is fabricated, now you can go in there and sue them and claim for everything else. So now you get to sue them twice. Why you get to sue them twice? Once they brought a claim in the court case, you must claim for damages for the process that they brought you and the resources that you have to use to defend yourself within the court. You can sanction them up to 75,000, depending upon the case in which they actually brought there, once they bring a fictitious action. So when you win this case, right here on the defensive side, you then turn it over to go on the offensive side and attack them again on the opposites that you win in the lower court. And the higher court, they will just sign out with you immediately and try to get you to sign some form of agreement without even go through litigation. Right?
Yeah.
So when you do that, though, make sure you report them to the Secretary of State or the Attorney General or whatever it is, so they can criminally prosecute them away and lock up their ass.
Gotcha. And the other
So
case I have, which I want to talk to, we still have to set up a meeting. It's my foreclosure case. They never served me a summons. They put an ad in the paper, and I went through my paperwork. I went into the e-portal, and I wanted to completely. The
Recording
judge
in progress.
ignored it, and I'm waiting now with my. They asked me to do an amended counterclaim, which I did, and I'm waiting now on that. And their attorney just filed something saying that the judge needs to sort of uh, put a move on it because he's taking too long. He submitted a case saying that on a foreclosure they should try to move the case rapidly so that they're not losing money, stuff like that.
Yeah, you will be able to win the case based on what you're telling me, but it's just dependent on how you write the documents, though. If you write the documentation without I don't know if you guys was here earlier when I was showing you have to follow the principle of the Federal Rule 8, how you say who, what, where, when, and how, and so forth. You must place a relief what you're looking for inside of that case, and you're going to tell them to dismiss the case, issue a quiet title, and after you issue the quiet title, they must give you an injunction that they don't bring any more claim of this fictitious action within the court, and you want them to be recommended for criminal prosecution. So if the judge if the judge still not did the judge just say denied, did they have to actually get a documentation saying denied?
I'm
I
sorry.
just did that
No,
they
they
just totally ignored.
so the first affirmative answers, I filed affirmative answers and counterclaim and defenses, and they came and filed a motion to dismiss my counterclaim. So he came and went in their favor and told me that I had to amend my counterclaim. So I went
So,
ahead and
so,
amended.
so
Go
you
ahead.
need to amend it because there's something that the judge recognizes that's not quite. So in other words, you are trying to attack this case. So you must look at the case that they filed and look for each point that they raise. If you don't understand the point that they raise, go get an AI and say, hey, I want to see all the points raised herein and all the claim that they brought and under what statutory thing that it brought it under. When it bring up all of those claims, you look at them and then you try to match the law that you know that is fabricated that they're using and attack that underneath your affirmative defense. Once you attack that underneath your affirmative defense, you'll be able to effectively attack it. But while you're attacking it, make sure you make what kind of request you're looking for within it. You must dismiss the case for cause. the cause is in violation of Federal Rule 12b-6 because it failed to state a claim whereby relief can be granted since the documentation is either material misrepresented or whatever you the claim might be. And then once you bring it up, say you want to penalize into the statutory penalize and have the state statute, and then you want to do a rescission on the state law, not the federal law, the state law. And once you do the rescission on the state law, you're gonna go for it. And man, I don't know why I'm keep talking about this because I'm not supposed to. It's about traffic.
I get it, and I sent you some money. I want to set that consult with you and go over it a little more personal, if you don't mind.
Yeah, because this is
Yeah.
for traffic, and I don't want
Yeah,
to do
that's
this at
fine.
this time. Right.
Okay,
So
we'll
yeah.
talk it later. Thank
All right.
you.
Mhm.
Hey, cool. Cool.
Guys, I have a question. Go ahead.
Hey, yeah, I just like to ask also regarding similar to that situation. Where can I like quick consultation with you, you and Derek or something like
Well,
that?
well, you can look at my TikTok. My TikTok has the same name.
TikTok is okay.
And then you see my contact information there. Somebody placed it inside of the
Okay.
place it in.
Recording in progress.
Called not necessary